In this installment of Washington Legal Foundation's Legally Brief, we are joined by Mike Kaler, an assistant professor of business law at Butler University, whose decade of legal practice at an international law firm has informed his work on the Foreign Corrupt Practices Act and facilitated the creation of his website, the FCPA Professor. Mr. Kaler, the Georgetown Journal of International Law recently published an article by you entitled "The Facade of FCPA Enforcement." What about the law's enforcement has become a facade?
Well, Glenn, the short answer to that question may be what, in terms of FCPA enforcement, isn't a facade. We have a situation here where Congress in 1977 passed the FCPA for a very specific and very narrow reason, and that was to prohibit the payment of things of value directly or indirectly to foreign government officials in order to, obtain or retain business. But you will see very, very little in these recent enforcement actions that actually have to do anything with foreign government officials or actually getting actual contracts. So there's a lot in terms of FCPA enforcement that people, rightfully so, scratch their head about. A couple weeks ago, Assistant Attorney General Brewer sort of declared this new era of FCPA enforcement. And I agree, there is a new era of FCPA enforcement. But the question that needs to be asked is why? It isn't because the statute has changed. It's not because I submit a court has completely legitimized certain of the enforcement theories. Rather, we're in a new era of FCPA enforcement simply because the enforcement theories have changed. And I submit that in many cases, those enforcement theories are contrary to the FCPA statutory provisions and contrary to the intent of Congress in enacting the FCPA. And all this takes place largely outside of the judicial system, where the DOJ and certainly the SEC, because it adopts many of these same legal interpretations, are acting both in the role of a fact finder and in the role of a judge or a jury, because these things are really never challenged. The DOJ has made it so easy for companies to settle these cases that whether intentionally or not, they are insulating their legal interpretations from judicial scrutiny in all but the rarest of circumstances. So what does this facade consist of? It consists of factually similar cases being prosecuted with different results. It includes situations where the most egregious instances of corporate bribery, per the DOJ's allegations, are resolved without FCPA anti-bribery charges, and it results in situations where it's highly questionable as to whether the allegations in the charging documents even satisfy the elements of the FCPA. You sort of wrap this all up, and you do have a facade of FCPA enforcement in many cases.
What are the dangers of having a law like the FCPA largely unaccountable to the federal judiciary?
Well, I think we all learned in law school, and even if we didn't go to law school, probably in high school civics lessons, that a judge and a jury facilitate the thoughtful presentation of conflicting ideas, of mitigating facts, of defenses. But because FCPA enforcement largely takes place via resolution vehicles that are privately negotiated, that are subject to really no meaningful judicial scrutiny, you have a situation where a law is developing completely outside of the judicial process. So for those who are in good faith attempting to comply with this law, there's very little other than what the enforcement agencies say for them to look at. This isn't an area of law that has a wealth of substantive case law. The statute in many cases is vague and ambiguous. The Fifth Circuit in the K case, really as high as an FCPA case has ever gotten, the Fifth Circuit in that case concluded that the obtain or retain business element was vague and ambiguous. So what you have then is a vague and ambiguous statute in many cases that is not backed up by a case law, and the gap filler, to use that term, is a resolution vehicle that is subject to no judicial scrutiny in many cases, and that is negotiated in the context of the DOJ, possessing some juicy carrots and some sharp sticks if the company or the individual doesn't agree with its interpretation of the facts or its conclusions of law. So anytime an area of law is developing outside the judicial process, you're going to have problems like this. And this just isn't any area of law. This is the FCPA, the most important U.S. law when it comes to doing business in overseas markets. Something, even small to medium-sized enterprises are doing nowadays very frequently because domestic markets have been saturated.
Now, you're testifying tomorrow at a Senate Judiciary Committee subcommittee hearing on the FCPA. Do you think Congress will be at all receptive to concerns about the FCPA enforcement and the multiple recent calls for substantive reform?
Well, by virtue of this hearing being called, I think the answer to that is yes, there is some concern here. Now, I don't have any unique insight into the timing of this hearing. It is a bit odd coming at the end of a Congress, but clearly Chairman Specter of the subcommittee does have some concerns, and I don't think there would be a hearing titled Examination of Enforcement of the FCPA unless there was some concern. It's going to be interesting to see what happens. There are some reform proposals that are out there, but already from a political standpoint, you already see sort of the toxic environment that's developing where people are calling these proposals pro-bribery or somehow akin to paving the way for business to go on a bribery binge. I think those are very naive and uninformed statements. In many respects, this brings us back to the 1980s where Congress was conducting some oversight hearings as to then the very young FCPA, and it took them 8 years, literally, for them to amend the FCPA to make it a better, strong statute. I believe that the FCPA is a fundamentally sound statute, but that does not mean that FCPA enforcement in many cases is fundamentally sound. And I think you're seeing a growing chorus of people, including former DOJ enforcement officials, basically saying, what are we really doing here? Is this the same statute? Is this the same level of enforcement that Congress had in mind when they passed this pioneering statute back in 1977? So hopefully this hearing can perhaps lay the foundation for additional hearings in the next Congress, because the time to examine FCPA enforcement, I think, is now. We are in this new era. I agree with that, but the question needs to be asked, why are we in this new era? And there will be some issues that Congress should be exploring to see if the new Congress can't make the FCPA perhaps a better statute consistent with the original intent of the 95th Congress in enacting the FCPA in 1977.
Thank you for joining us.